Good afternoon, everybody. I'm David Levy, Dean of the Law School, and with me this afternoon is Todd Christofferson, who is our graduate from 1972 and is an elder of the Mormon Church. And welcome back to your law school.
Thank you.
Great to have you here.
No exams today, I hope.
No exams today. It's an oral exam.
Oh, okay.
And welcome to your family.
Thank you.
To your wife Kathy, and is it Brenda?
Very good.
And to your son Peter, who is also a graduate of the Duke Law School, 2003. So welcome all, and welcome to our audience. Why don't we? You've had such a distinguished career in law and in the church. Why don't we just start at the beginning and kind of where you grew up and what brought you to Duke Law School?
I was born in a little town in Utah. We had a small farm there, some sheep and a cow, and the cow was there for discipline. Because you have to milk it every morning, every evening, and there's no excuses. No way around it. When I was in high school, my family moved to New Jersey. My father was a veterinarian, and he took a job with Squibb, which was headquartered in New Brunswick for animal drug research and testing. And that was obviously a cultural change, as an understatement. But to me, a marvelous experience, really. I know New Jersey doesn't have a great reputation among all the states, but to me it's one of the best for the experiences I had as a young person there. I served a mission for the church, leaving
Just so
from
we don't
there.
get any letters from our New Jersey alumni, we'll just make it clear that it doesn't have a reputation for a rural life, but actually it does. It has some beautiful places.
Yeah,
yes.
it does that. In fact, my summer jobs there were on farms, so it does
Right.
even has a rural life.
Yes.
But I served the 2 years in Argentina, learned Spanish, and came back. My family had moved to Chicago by then, and I found them and was reunited. But I took up I had done my freshman year at Brigham Young University and came back and finished a degree there in English. And in the course of that, met Kathy, who became my wife. We were married at the end of our junior year and then graduated together the day after our first anniversary. And then packed everything up at the end of summer and came here.
And why law? Why Duke?
I'm still asking myself. We had no ties with the South, the southeastern part of the United States, either of us in our background. There was an assistant dean here at the time, though, who was Latter-day Saint and was somebody I spoke to as I was looking at different schools around the country. And he was very high on it. We had a couple other graduates from Brigham Young that were here at the time who sold me on Duke, and the bottom line is they accepted me.
That helps.
So I came. But I was, even then, not sure I was going to practice law. You know, it was one of those, I suppose there are others in the same boat here who thought, this is a good background for flexibility in life, whether I want to go into government, to politics, to business, to law. It's just a good foundation for many other things. And so I hadn't fully decided on that at the time. It was not until I had a clerkship or an internship with a law firm after my second year that I found I really liked law practice and went that direction.
Now you came here, it would have been 1969.
69, right.
So a time of very great ferment in the country, the civil rights movement.
Vietnam. Cambodia.
You faced the prospect of being drafted.
I was drafted.
You were drafted.
And then I joined the ROTC. So while I was here, interestingly enough, I spent 2 days a week over at NC State in ROTC classes. I graduated there in 71 and then here in 72.
So what was the law school like in that time, in that historical time?
Historical, wow.
Well, at that, I didn't mean it to sound quite that profound. I just meant, well, you know, what did you find here?
Well, it was a great diversity, and I trust it still is, as far as where the students came from in different parts of this country and a few other countries. There was a lot of ferment, as you say, on political issues. I was told later that the faculty really wondered what to do with this class because they were so unruly. We had, I remember, you know, a big meeting in the moot courtroom when the U.S. invaded Cambodia. This is historical. That part of most of you won't remember that, but there was the war in Vietnam was going strong in Vietnam, but then the president decided to take it into Cambodia because of the supply lines for the Viet Cong and North Vietnamese that came through there, and that created a huge uproar in the country and here. And in fact, I was really surprised how good as advocates my classmates were, because they convinced the then administration to let those who wanted to go to Washington and demonstrate take their finals in the fall and have time off to go demonstrate. I didn't think anybody could sell that idea to the professors, but they did.
It was a very great incentive.
So it was.
I remember that time.
But I enjoyed it in part because it was not a massive student body in terms of numbers, and people could know each other and could interact with each other and get to know different perspectives.
Your classmates describe you as one of the great unifiers in the class. Do you have that sense of yourself as somebody who was able to work among different groups of students?
That's interesting. I hadn't heard that. But you know, that's something I think is important. And I believe that that's, frankly, one of the skills that law can train you in. And I know that there are those who say, you know, the lawyers are there to create the chaos. To me, they're there to bring order out of chaos and to compose matters and to bring reconciliation and the best benefit for the largest number possible. So to me, that's really one of the fruits of a legal background, legal training, and the profession itself.
I'm so glad to hear you say that. I occasionally say that I think lawyers have the potential to be social healers.
Yeah.
And this provokes a fair amount of mirth sometimes. But I think there's a lot of truth to it.
Well, it ought to be. I mean, obviously there are those in our profession who don't, but as a profession, I think that's of the essence of what lawyers do.
So let's take you to graduation and to what was obviously a very exciting phase in your life, your clerkship with Judge Sirica, just as Watergate came to his courtroom. What took you to the clerkship?
I wish I could say again that I had planned this out since I was 12 or something, but it was an idea that only occurred to me in talking with some of my classmates who were applying for clerkships at the end of our second year, beginning of the third year. And I was cognizant of that possibility, but the way they talked about it and the fact that they were actually doing it made me say to myself, maybe I should. And I didn't know what the options were, and I know that it's probably even more difficult now than it was then to secure a clerkship, but I did apply to judges in Washington, D.C., and Denver, Colorado, and San Francisco, where I thought I might end up at some point. And I got a letter back. This would have been the late fall of 71, I guess, third year, from Judge Sirica in Washington, the district court, and invited me up for an interview. He interviewed two of us from Duke, as it turned out. I didn't know that at the time, but he had a couple of us, and he's pretty conservative in his outlook on things, and I think I got the job because my haircut was shorter than the other guy that applied.
You never know.
But it was one of those things where you do hit things off well, and had a good feeling about it from the beginning. And he hired me at that point, or shortly after that, to begin in August of '72. And it was in June of '72, between him hiring me for later and then when I actually started, that this Watergate break-in took place. So it was nothing that anybody anticipated. And when he assigned the case to himself, he was the chief judge in the District of Columbia at that time, and he, I guess it was 68, 69, he turned 70 while I was with him. But it was toward the end of his career on the bench, and he took the case, and starting in September of '72, the first indictments came down. That was mostly Watergate after that.
Was he, do you recall which president appointed him?
Eisenhower.
So he was Republican appointee.
He had campaigned in the Italian-American community actively for the Eisenhower-Nixon ticket both times.
So a little Watergate 101. Many of the people in the room know this, but a shocking number of people in the room probably have no idea or very little idea of what Watergate was. The Watergate is a hotel apartment building in Washington, D.C., which is, I think, now fallen on rather hard times, although back in the early '70s it was considered to be a place of some elegance. You can see it from the Potomac River. It's a kind of a rounded building near the Kennedy Center. And in June of '72, a group of Cuban Americans who were acting under the direction of a group of people who were loosely associated with the re-election campaign for President Nixon. That was the year he ran against George McGovern. Broke into the Democratic headquarters, which was located in an office in the Watergate. So it was, if you've seen Forrest Gump, you know what I'm talking about. And they were caught miraculously. They were actually caught on scene, and they were arrested, and then they denied any political connection for the longest time, and they were paid hush money. These are the people who actually went in, and the whole story started to come out very slowly. There were two Washington Post reporters who were reporting very vigorously on this. There was Deep Throat, who turned out to be Mark Felt at the FBI, who was feeding them information about it. And there were, I think it's fair to say, there were two phases to Watergate. There was the entry, the actual break-in, and then there was the cover-up phase. And it was the cover-up phase which took President Nixon down. Is that a pretty good summary? So,
yes.
So when you got to Judge Sirica, you say the indictments came down shortly after you got there. So the first set of indictments would have been against.
These were the four Cuban Americans from Miami, and James McCord, who was sort of their mentor or leader, and was handler, who was present at the same time in the break-in, and Gordon Liddy and Howard Hunt. Howard Hunt formerly worked for the CIA. Gordon Liddy was a lawyer, unfortunately, who had run for Congress in the state of New York, narrowly lost, and was an employee of the committee to re-elect the president, as you said. And they had furnished the money, the financing behind it. It was interesting. The idea was one that was hatched by Liddy, that they would go into the offices, plant electronic eavesdropping devices, bug the phones, and it was an extremely elaborate plan, actually, that involved even some strategic kidnappings, as he put it, and intercepting mail and all the rest. And they were going to interfere with the convention that year of the Democratic Party. And just to deviate a little bit, he had proposed all of this to John Mitchell, then the Attorney General of the United States, soon to be officially the campaign manager for that re-election campaign, distinguished attorney from a law firm in New York. And I'll never know why. This is one of the saddest things of the whole affair, that Mitchell, when he heard this from this volunteer/employee of the Reelection Committee in his office, the Attorney General of the United States, this elaborate plan, $1 million eavesdropping and all the rest, did not fire him and throw him out and chase him into the river. But he said, all he said was, it costs too much. And if it was a hint, Liddy didn't take the hint.
No.
He came back with a $500,000 version, and they got the same answer, and he finally came with a $250,000 version. And it was approved. I mean, he got a green light, and they went in and they did plant these eavesdropping devices, and it was 2 weeks later, when some of them weren't functioning well, that they went back again to fix them, and that's the point when they were caught.
It was a technological problem.
That's right. To bring it into modern times.
Yeah.
But it was just a humorous kind of thing. There was a door into the parking lot that gave them access to this Watergate office building, and one of them had taped the latch so that it wouldn't catch, and they could come in through the parking lot after hours and get into the building. And if you can believe it, I mean, I'm not even. I don't have much spook training in my background. I would have taped it along the edge of the door, I would think. They taped it around like this. And so when the guard came along and saw this, that shouldn't be there, and he took it off. And they came back later, oh, the tape's gone. They put it back on the same way. So they deserved to be caught.
So that was the first trial. And what was your role in helping the judge during that trial?
Well, there were a constant flood, as you know, from your own experience, of motions on evidence and other issues. Much of my work was to summarize those and give him the summary of the pros and cons and some potential orders. I would do some drafting, and he was very good about talking about these things. He'd like to use his law clerk as someone to bounce ideas off of, and that was true through the balance of my clerkship with him, which was a great benefit to me. I think that was really a tremendous education to have the benefit, really, of his years of experience in the law in those kinds of discussions.
Were you the only law clerk?
He had another who was there part-time, who was in law school at the time in Catholic University, and Richard Azzaro, and so he was devoting part-time between school and clerking. Was a great help as well.
I mean, it's hard to think back about the intensity of the public interest in these trials. I mean, this was riveting. This was on the news every evening. There must have been television trucks surrounding the courthouse every day. I'm sure you were very aware that you were involved in something extraordinary.
And Judge Sirica said, look, I don't want to deal with the press. You go do it. And I was really a novice, but I learned a lot. I learned, for example, when a reporter calls up and asks a question on the phone or even in person, and you answer it and they are silent, that it's a great technique to get you to keep talking and say more and more things you probably shouldn't say in the end. But I learned you give your answer and you stop. And if they're quiet, so be it. So let them ask another question.
Yeah, that's interesting. So that probably was that part of your job was probably pretty significant.
It was. It turned out to be, but it would vary, as the action would shift from time to time to Capitol Hill, and the Senate Select Committee was appointed to investigate all of this. Then the flood of reporters and press would go up to Capitol Hill, and we were alone, and then the action would come back to the court for a hearing or something, and they'd all flood back. And it gave me a little lesson in a dose of humility too, because when you're in the middle of something, you're very important, but when it moves away, they don't know you.
So there was a point at which the special prosecutor, Archibald Cox, on behalf of the grand jury that had been impaneled, subpoenaed the president for records.
Right. part of the progress of it after that first break-in trial, there were a lot of suspicions of cover-up. That is, that some of the witnesses had lied and that those who were really responsible above the level of Gordon Liddy had been protected or hidden. And so the investigation pursued in part through the press, as you said. And in the end, a special prosecutor was appointed, and it was Archibald Cox. It was revealed in those Senate hearings that, in fact, the meetings, all that took place in the Oval Office and in the President's ancillary office in the Executive Office building next door, had been recorded. And when that was discovered, everybody said, well, let's get the tapes. There's the answer. I mean, you have John Dean over here, his counsel, White House counsel, saying this, the President and his aides saying that, and the tapes will show us what's right.
Yes.
So there was that subpoena for the tapes, and that became a great legal battle issue of its own once their existence was acknowledged.
So that was had the makings of a constitutional crisis of a sort at that point. And did that come to Judge Sirica?
It did. It did. That was in the summer, I guess, of '73, around that time, and my clerkship was scheduled to end at that point, and he said, you need to stay another year. We're right in the middle of something interesting.
And did that seem like a good idea to you?
It did to me. Yeah. I was willing.
I mean,
He had to convince the Army to give me one more deferment than the law firm I was going to go with to wait another year, but he was successful.
Yes. So how was that? I mean, that was the biggest case of the moment and of the time, and it's still a very big case. How do you remember some of the personalities involved in the courtroom, the lawyers in particular?
Yes, and I should say that they're the ones who really made me proud of the profession I'd chosen to go into. I was starting to worry seeing someone like Gordon Liddy and others who had dishonored the profession, I felt. And then, on the other hand, here were some of the great titans of the law. Cox, we mentioned, St. Clair, who was one of the President's counsel, Charles Allen Wright, University of Texas, who represented the White House in these tapes matters. And I'll always remember, I think, that moment in the ceremonial courtroom, the large ceremonial courtroom there in the federal courthouse at the foot of Capitol Hill. On the hearing, that is, should this subpoena to the President for the tapes be enforced? Could it be enforced by a court? It had come from the grand jury. There was Cox on one side and Wright on the other, and others assisting them, and the statues on the back wall, Solon and Moses and Socrates and others looking down. And it was just, I thought, boy, this is really a great climax. It was the beginning of my career, but it seemed like a climax, a real high point. And I thought, this is why we have law, why we have lawyers of noble profession. But it was a novel question in the end, and as we researched this, it was the only precedent we could find about a sitting president of the United States having a subpoena to produce evidence in a criminal trial was Thomas Jefferson. So not a lot in the meantime to look to. And in that case, it never really quite got to the point of decision because they settled on a compromise, an excised, redacted version of the letter was sufficient, and that was that. But this was really, I think, the first instance where there had been a subpoena and the court ordered enforcement. And then I guess you have the letter here now that the President wrote back.
Well, why don't we talk about the letter a little bit? I think everybody in the room is aware that this was really just a dispute among alumni of the Duke Law School between you and another alum.
Dick and I, yeah.
Yes, you and Richard Nixon. It's a shame you couldn't have just worked it out that way. But he eventually actually wrote a direct letter to to Judge Sirica in his, I believe in his own handwriting. Am I right about that?
He signed it anyway.
He signed
I
it.
don't remember if it was
And
hand or not.
do you have any recollections about the letter arriving or anything of that sort?
It's a little vague. I know it didn't come in an open court setting. As I recall, it was delivered to chambers to the judge.
Well, we have the letter is part of the collection of our library. It was treated as if it were a personal letter to the judge, and it was not actually filed in the courthouse. And it eventually, I think after Judge Sirica's death, it went to his son, who then donated it to us. This is a little bit unusual, but this was the president's, I suppose, his way of showing respect to the judge and explaining why it was that he was going to not show respect to the judge's order enforcing the subpoena.
Exactly.
And then it went on up.
Yeah.
It went on up to the Supreme Court, and it's.
In the first instance, it got to the Court of Appeals, and trying to remember exactly what took place there. I think before they could make a final ruling on that, he said it was going to take a different approach. He was going to have Senator Stennis of Mississippi listen to the tapes. He was a very old man at that point, and his hearing was not that good. And the tapes weren't all that good either in some cases. Some were crystal clear, but some were not. And that he would decide what could be produced and what couldn't, and that led to what's called the Saturday Night Massacre, when he fired the special prosecutor and his staff. And the great public outcry to that resulted in his finally yielding and presenting or appointing another prosecutor, Leon Jaworski, to carry on that role, and eventually the tapes were in fact produced. Then there came a second round of these when the cover-up trial came about. Those who had been part of the cover-up. Later in '74, there was another subpoena for another round of these tapes, same objection. And this time it did go to the Supreme Court. Okay. And there was a unanimous ruling in favor of producing them, and that was kind of the end. I mean, after those became public, it was clear that the president had lied about not being involved with anything concerning the cover-up. I don't think it was involved with the break-in or anything preceding it, but he had not told the truth and been forthright about his role in trying to hide the facts, and the involvement of some of his staff and re-election committee. And that kind of outcry led to his resignation.
Let's talk a little bit about the second trial, and then we'll move on to your law career thereafter. The second trial involved Haldeman, Ehrlichman, Mitchell. So these are the Haldeman and Ehrlichman were the president's chiefs of staff. Mitchell, the former attorney general. This was a very high-profile trial. You were used to high-profile trials by that point, but did you have the same role, more or less, as you?
Same role, helping in reviewing the motions, drafting opinions with him, and he had both of his clerks, Rich Azaro and I, always in the courtroom to hear the proceedings, to be there on the scene and get it firsthand instead of him telling us this or that happened, check on that. So it was a continuing education, but a very, as I recall, busy time. There always was something.
You know, what reflections might you have on Judge Sirica and what he did for you?
Well, he made me a believer in the value of judicial clerkships. And I guess not all are the same experience, obviously. In fact, he said to me once, "I hope you appreciate this. Not many law clerks get an experience like this." Yeah. And then he stopped and said, "I guess not many judges do either."
That's true.
But his style was to involve us personally. You know, he was not standoffish in any way, and as I said earlier, was anxious to talk things through. There was a point where he thought maybe his own office, his own chambers were bugged. We all got paranoid after all that we heard about this. And so he would come in the morning. They had a little cafeteria in the basement of the courthouse. And he parked his car underneath, and he would call me when he got to that point. I was up in the chambers, and come on down. And we'd go down, and we'd find a table at the corner there where he said, it can't be bugged here. And he'd have his coffee, I'd have my chocolate milk, and we would just talk about the day and what was coming and some of the issues that he wanted us to pursue that day. But after a while, he got his office checked, and there wasn't anything. And then later after that, he said, I wonder if the FBI is trustworthy, if they really... Did they plant something, or did they just sweep it out? But it was a very collegial kind of relationship, which I deeply appreciated. It's meant a lot to me. And we had just a close personal relationship that continued on after. When I was in Washington after that, we would go to dinner together. But I was very honored when he passed away that his family asked me to speak at the funeral mass in his honor. And that to me was a great moment.
He was known, I recall, at the time as not as having a fairly lively temper, shall we say? He could. There were at
somewhat
times
volatile.
Somewhat volatile. It was part of your function, just sort of helping him cool off from time to time.
One of the attorneys who represented Haldeman was a former colleague of the judges. They'd worked together in the U.S. Attorney's Office in D.C. as young lawyers growing up. His name was John Wilson, and Wilson knew him well. Wilson knew he didn't have much of a case on the evidence, and so his strategy was to needle the judge, get him upset, and hope that he would commit some kind of reversible error that would get his client off on appeal. And he was having some success from time to time, and the judge was wise enough to call a recess. We could go back to chambers and let off steam. And I'd say, Judge, he's just trying to get, I know, but it makes me... And he'd call him after a while, and we'd go back again. But he was, I guess what we would say today, a real person, not any pretense.
Yeah.
He'd gone to law school in the days when you didn't have to have a college degree. You could go straight from high school to law school. And he said, I wasn't prepared, and he went to Georgetown. He flunked out. And he tried a second time and didn't make it, and finally the third time. And he succeeded, and he was grateful to Georgetown all his life after that for having given him 3 tries to succeed, and he did succeed. And even then, though,
do that.
times have changed. Even then, though, he wasn't sure he was going to practice law. He was very interested in a boxing career. He wanted to be a professional boxer, and so he had a bout or two. And he said, my mother shamed me into practicing law. She said, "You've had this marvelous education. You've got to put it to use." And so he did.
And he had great character and integrity.
He did. And
you couldn't push him around.
It came a lot through his trial experience. He started out in the police courts where he would sit in the back, and here comes an indigent defendant. The judge says, "You represent him." Just right at the ground zero where the rubber meets the road, and grew up in trial practice that way, and then in the U.S. Attorney's Office, and then in Hogan & Hartson, a large firm in Washington. But there was nothing new, I guess, that he hadn't seen that came up while I was with him. And the one thing that really angered him more than anything else I've ever heard or seen in his talking about it was a judge who would not honor his position, who could be led around, so to speak, by counsel, or who wouldn't be strictly honorable and impose the rule of law and observe the rule of law and not show favoritism.
Yeah.
And he had had that experience as a trial lawyer. He said, that will not happen in my court. And in that first trial, when he thought someone was lying in his court, that angered him tremendously. We'd go back into chambers at a break and he'd say, "Somebody's lying in my court." And it truly angered him. He was a very upright person, personally and in the profession.
He was quite a hero, really. it was very important what he did.
Yeah. I
So-
was impressed, by the way, at the moment he signed that order for the subpoena for these tape recordings to be enforced. It was a moment when nobody knew how that was going to turn out, and he could have been a goat as well as a hero. I mean, he could have had his head handed to him on a platter by the Supreme Court, as for all we knew. But I remember him poised with his pen in his hand at that moment, just one last thought going through his mind, is this right? And he said that, this is right, and he signed it.
That's very dramatic. So after the clerkship, then I think you went into the Army.
For a few months, some active duty that had been delayed all that period of time,
And then
with a law firm.
and then to a law firm. And then you had how many years of practice?
Well, counting that clerkship, the 2 years clerkship and the law firm, and then I was in-house counsel after that with the hospital corporation and bank that ended up being part of Bank of America. 21 years, I guess.
That's a good long time. Did you enjoy the practice of law?
I did. I wish I could say I enjoyed every day of it. But all of you know billable hours become a crushing burden at times. And there are clients you like to work with and some that are not so comfortable to work with. But I enjoyed the experience both on the law firm side of things and on the in-house counsel. And I have to say, I can count myself very fortunate to have spent my legal career, as long as it lasted, in the company of very good people. I think who you work with, the kind of people they are, makes all the difference.
It does, doesn't it? Yeah, it's really important. How did you deal with the stresses and strains of practice? There's a degree of incivility, there's a degree of friction that's perhaps part of the structure of an adversary system, and then there are a few people out there that are bona fide jerks and just, try to make life difficult for everybody. How, particularly given your religious background, how did you deal with that?
Well, there is a great variety of experience for anyone who's, as you know, who's been in the law for any length of time. And I think you have to accept the fact that there is that range of personalities and not expect, frankly, that you're going to always have cases where the law and the facts are on your side, and always have cases where the people are honorable. A lot of it's in the expectations. With false expectations, I think you really may be living a very disappointed and disappointing life. But I see them or saw them as challenges, as opportunities in a way, and opportunities to learn, really. I think you can learn from anyone. And some of what you learn is what not to do and what not to be like. But other times, even the assistant clerk in the court has got something to teach you, if you pay attention and know something about them and their background and give them a chance to talk and hear them out. But I think if one does his best or her best to be honorable, you can deal with those personalities and situations, and while it's not always pleasant, at least you preserve your integrity.
Did you foresee that there would be a point when you would leave the practice of law and do something in your church?
No, there are, I guess that's always a possibility in the way we're structured in the church. It's a lay leadership, and I had served in earlier years when our family was younger in Maryland as a bishop, and that's the head of a congregation for a period of 4 years, 6 years. It's typically around that amount of time, and then you're released and someone else carries on with that responsibility. And everyone, our goal is to have everyone with some part of responsibility in the congregation for teaching or activity or whatever the case may be, with the children, the youth, the scouts, the whatever. So certainly we've been used all our lives to being active and involved and spending some time, committing some time there. This was a full-time assignment, or calling as we refer to it, and it's not something you train for. There's not a career path that leads you there. There's no basis on which you would expect that might happen. When that came to me in 1993, I was working in the General Counsel's office of Nations Bank, which later became Bank of America. I didn't know how they could get along without me, and they did all right up until
For a
recently.
while.
Maybe they need me again.
Yeah, maybe.
But when I talked to the General Counsel, I was the associate, and I talked to the General Counsel and told him what had happened. He said, "I didn't even know that was a possibility." And I said, "I wasn't so sure it was either." But our practice, our tradition, our commitment really is that we respond to these calls, whether it's a part-time or a full-time kind of assignment. The mission itself, for example.
You don't say
in
no.
youth, you don't say no. So my career was going, I felt like this, and then it took a quick turn.
Yeah. So could we talk about what some of your duties are, and I think they may have changed, because the first call was not. Well, why don't you describe it?
We have in the general church organization at that level a president and two counselors. We refer to them as the first presidency, the highest presidency or directing body in the church. And then operating in tandem with them and at their direction are the 12 apostles, the quorum of the 12 apostles. We see it as the same organization of the church that Christ himself established in his ministry. And then there are some vague references or passing references in the New Testament to someone called the 70. That is, he called 70 other elders after these 12. And so that's in this church an office or a group that work under the direction, become an extension of the 12, if you will. And as the church grows, that number grows as well. So my first assignment was in this group of the 70, a quorum of the 70, as we call it. And that's kind of a more hands-on administrative assignment, often in one particular geographic location. So our first assignment was in Mexico City, and we lived there for 3 years. Our youngest two sons and my wife and I knew Spanish from Argentina. They learned Spanish while they were there, although one of those boys who was with us in Mexico was later called as a missionary in Spain. And when he got there, he said, "I don't know what they're speaking here, but it's not what we spoke in Mexico." But that is I guess you'd say a temporary assignment, in the sense that you serve for a period of years and then that release comes. In the case of the 12, that's a lifetime appointment, so there's only one way to get out of it.
Sort of like
but that's a more overarching responsibility for the church's activities and work across the world. And, we look back to that Grand Commission, that we call it, the Great Commission that Jesus gave to his original apostles as he finished his ministry here. Said, "Go ye therefore into all the world, teach the gospel." So at the bottom, that's it. It's teaching, and teaching in the church and in other settings.
It's a large church. It's an international organization. There must be an enormous amount of responsibility and administration that goes into operating something of that size, and it's just the day-to-day activities, I'm sure. I wonder whether you find that your experience of the law has helped prepare you in any way, whether it's for administration or in the qualities of mind or character that you have, or just how you see, whether you see continuity in your life.
I do, and I'll ever be grateful, I think, for legal training, legal education, and legal practice experience as well. there's no prerequisite, for sort of basic training or background that's required, and there's a good variety of professional pasts represented among the current quorum. The 12, 3 of us have been in the law. One is a former heart surgeon. A couple have been businessmen. 3 of them, I think, have an academic background in teaching and university administration and so forth. So there's a wide variety, but we always tell the other 9, the 3 of us, that we can indulge their lack of ability in some things, knowing that they didn't have legal training.
Certainly appreciate that.
In seriousness, there's, I think, the rigor of it, the tools and abilities that come in analyzing things, in organizing things, just organizing an argument, organizing a case for trial, for example, or organizing an argument in a brief, organizing an answer in an exam, analyzing the facts and drawing out what's significant and laying aside what's not significant, and identifying the difference. And all of that, I think, has been extremely helpful to me, as well as the relationships with people, as you were alluding to earlier, some difficult, some with certified jerks, and with very good people on the other hand. But all of that is working in sometimes high pressure, tense situations has been tremendous. And I'm particularly grateful for the writing skills that have come out of that. I don't know that I'm a great writer. I'm certainly not qualify well as a creative writer, but the ability to express something with clarity and with persuasiveness is a valuable commodity, and I see it lacking many places in many settings where someone cannot simply express a thought or a concept in a clear way.
I read a recent talk by Dallin Oaks, who is another elder of the church and had a very distinguished legal career as a judge and as a law professor, in which he writes that one of the tenets of the faith is a belief in moral absolutes. And I'm interested to know how that works in a setting in which you are so international and where cultures are so different from one from the other.
Well, you're right. There is, in our view, a God, a Son of God, a law, a universal and divine law that He has established for the happiness and progress of those of us whom He has created, which is about 100%. And you're right that as the church expands around the world, right about 14 million, and the majority now are outside of this country, even though it was founded here in 1830. You run into many cultures, many traditions, and some of them are neutral or even consistent with that moral standard that we teach. Some are not. Some are inconsistent. And what we try to establish really is a church culture, which we hope takes the best of the variety of cultures that are there in the world, and encourages people to leave aside that which is not. Just a simple example, in some Pacific Island cultures, wife beating and children beating is part of the culture. I mean, that's considered normal and acceptable, and just how you run your family. And our teaching obviously is counter to that. And over time, I think we succeed in establishing a unique culture that has the positives and leaves aside the negatives. I was thinking one of my colleagues was in Papua New Guinea, talking on this subject, and he was the translator was translating from English to Pidgin English. And he made a comment, something like, "Don't beat your children." And the translation was, "No kill 'em pickaninny." He said, I didn't say don't kill him. I said, no. He said, oh, kill him is no kill him dead pickaninny. But it's, you know, it's not without its tensions, but our fundamental belief, really knowledge, is that, that the truths that are absolute, universal, and enduring are the source of happiness and, in the end, realization of the full potential of men and women. And so we make no apology for teaching it. We think it's the solution to so many other problems that we're happy to talk about it.
So it's no secret that the church has positions on some issues that are in the political context or are in the social world controversial. Some of them involve constitutional issues. You probably studied them as a law student even,
right.
Abortion, equality, gender equality, sexual orientation, those sorts of issues that involve, I would just say broadly, family and the way in which we kind of organize ourselves into
right.
family units. And I wonder whether your law background, my purpose isn't to debate the issues, but just to ask whether as a law student, as a lawyer, and now as a member of the Quorum, whether you think you bring some kind of unique perspective on these issues? Are you in a position perhaps to better advise?
I hope so. But it is a conversation, it is a discussion that should be had in the country, in the world, in the political realm. And religious voices, other voices, all ought to be heard. And as you say, the Constitution, I think, envisions that those kinds of discussions would take place, and that the people in due course make their decision, and it is what it is. Another example from some time ago, back in the 60s, there was, as you may recall, a movement in this country toward no-fault divorce. And it was one that we opposed, thinking that it would truly weaken the marriage as an institution and families, and we think it has. Not that divorce is never justified. There are certainly cases where it is and ought to happen, but where it can be without reason or for any reason, weakens those ties and lessens the security of children and families and all the other downsides that we foresaw at that time. We were part of the public debate on that issue at the time. It didn't go the way we were arguing. It went in favor of no-fault divorce. I don't know how these other issues will come out in the end, but it is a conversation, a discussion, a debate that needs to happen, and it shouldn't be cut off with saying, well, your position is illegitimate because it has a religious base, or yours is illegitimate because it doesn't have any religious foundation. It just needs to go forward, and I feel like in our case, for example, it's important to communicate, as I hope law training helps a person communicate, where we are and where we're not. For example, it's easy to say your stance on same-sex marriage, for example, is anti-gay. And you'll never convince some otherwise. But I think if we can be the communicators we ought to be, then that can be taken out of the debate, that bitter pill, so to speak, that allows a better and a more rational discussion to go forward. We do have a position about same-sex marriage, and we say it's is not going to lead to the family, the strength, the foundational organization of society being maintained. It's a redefinition, and we say we think that's wrong. But at the same time, we see every right that ought to be there for someone of that gender orientation in hiring and housing and all those kinds of things ought to be in place. And it was just, I think, just past January, we adopted in Salt Lake City a non-discrimination ordinance that, with the support of the church, that wouldn't have happened without that support, that I think is a model, really, for cities and states. But in all of that, without getting into, as you say, all the merits, pro and con, all of that requires, I think, that we honor opposing opinions, speaking of us in the church, that others do the same, and that there be enough clarity of expression and understanding of our own position. Sometimes the lack of clarity comes from not fully having thought out your own position and analyzed it from all angles. That I think then, you know, people will decide, and that's what our system is, our pluralistic democracy.
I'm going to open it up for questions here in a moment, but before I do that, just as, let's just say as a sort of concluding reflections, what advice would you have to a young lawyer coming out of Duke Law School now who wants to follow the path of Todd Christofferson as opposed to the path of, well, let us just say the other kinds of lawyers involved in Watergate, and lead a moral life in the law?
Get a job. I guess after 38 years you can qualify as a sage, right?
Yes.
Excuse me. I think your phrase is the right one, to lead a moral life. And to me, if I look back on that Watergate experience we were talking about earlier, Richard Nixon, a graduate of this school and someone who did very well here, eventually becomes President of the United States, and my hat is off to anyone who can achieve that. You know, whether you agree with their political positions and direction, that is some achievement. That is a unique and remarkable person. And as I listened to those hours and hours of tapes, with his conversations with others, and they're going around and around how to resolve the morass that had developed by one bad decision after another, it struck me that his involvement came from a very human tendency to try to look out for your friends and be protective. He hadn't, as I say, I don't think he'd been any part of the break-in or any of that planning or scheme. But it was shortly afterward when he was advised that those who were responsible, including John Mitchell, were his people. And the suggestion was made we could have the CIA director go over and tell Patrick Gray at the FBI that they shouldn't pursue this money that they found on these men. That's a matter of national security. And that was the first effort to try to cover it up. It didn't work, didn't last very long, and then they went on to one thing or another. But it was at that point that he got involved and committed a crime, I think, without realizing it. And I looked at that and was thinking, you know, here he's probably thinking in his mind, no harm was done, nothing of any value was taken or obtained, and why should I throw my friend John Mitchell to the wolves in the press when really it wasn't a big deal? And that was the initial step. And I still remember Senator Sam Ervin from North Carolina with his bouncing eyebrows, who would sit there in the Senate hearing and say, "Oh, what a tangled web we weave when first we practice to deceive." But I concluded after all of that, you know, and seeing some other people my age then working in the White House who got tangled in it almost unawares, the only thing that really is your safety is to stand on that rock of honesty, of integrity. If you ever step off, maybe you'll be okay, maybe you'll get by, maybe you'll get away with it, but there is no safety otherwise than whatever the cost may be, maintaining your integrity in relationship with clients, in relationship with other attorneys, at home with your wife and your children and husband, whatever. If you ever once make an exception, you're unprotected. So I'm for being firm on that rock.
Well, that's such a marvelous answer. Let's leave it there. And thank our guest very much for being here today. Thank you so much.